Alright, so this is the introduction of our business law journey. So we start with chapter 2 with some foundational concepts for the whole course. So we're gonna look at how law is defined, and once it is defined, we can identify types of law in Canada, and then we'll briefly distinguish civil law system and common law system. Both are present in Canada, so that's why we need to be able to differentiate them. How powers are divided under the Constitution, and we'll also briefly look at Indigenous rights and self-government, and we'll end at looking at rights, human rights, and we'll have to distinguish how our rights are protected when they are infringed or abused upon by either the government or by other individuals. So that's the plan for this lecture. Let's start with law. So we're not in law school, so we could spend in law school, we would spend 1-2 months defining what law is. But here we don't. We just go straight forward to a definition of law, which is this body of rules, and those rules uh, are the ones that can be enforced either by courts or by other governmental agencies. So courts, whenever one sues the other, so let's say I am suing a company because the product I purchased caused me loss, the courts, they will enforce laws, they will apply laws, they will interpret laws, and then they will render a decision. And examples with governmental agencies, let me give you some. Well, one is a police department. When a police officer pulls us over when we are driving, they are doing this because the law allows them to do this. So that's an example. Another one, CRA. CRA, we have a deadline to file our income tax. That is June 1st. Why do they impose as a deadline? Because there's a law that allows CRA to impose such deadline. So those are examples of laws which should be understood as this body of rules, because there are several rules, different types of rules. And whenever a court or a governmental agency applies them, then they are considered to be law. And law and morality, they are not synonymous. Why are they not synonymous? Well, most laws, they carry good moral value. Why? Because most laws are passed by politicians, by the parliament, and citizens of a country, they elect those politicians. So usually politicians will carry a similar moral value of the population. But it is not always the case. And I'll give you an example with marijuana. So possession of marijuana used to be illegal up to a certain quantity. It used to be illegal. So for some people, this illegality was also moral, had good moral values. But for others, this illegality was not right. They believed it should be changed. So it was immoral to make possession of certain quantity of marijuana illegal. So then the law changed, the criminal code changed, and now it is legal to possess some quantity of marijuana. And then now some people believe this is moral. This carries a good moral value. But others that are against, they believe this is immoral. This does not carry good moral value. So again, in most cases, law and morality, they go together, but that's not always the case. Okay, moving on, we have this distinction of substantive law and procedural law. So, substantive law is the law that tells us what rights we have. So, as a foreigner, if I am enrolled in a full-time course here in Canada, I have a right to enter Canada with a study permit. This is substantive law. I have a right. Whereas if I'm married or I am in a common law relationship and my partner studies full time as a foreigner as well, I have a right to have a work permit. So those are examples of substantive law. We have rights or there are restrictions. Um, we have a right to counsel whenever we are facing criminal procedures. So this is another example of substantive law. Procedural law is related to procedures. So what procedure do I have to follow so that I can exercise my right? Well, I just exemplified that I have a right to a study permit if I'm enrolled in a full-time course in Canada. How do I apply to such study permit? These will be procedural laws. So what documents I have to file, where I have to file, how if I need to pay any fees. So whenever I'm talking about the procedure of exercising any right, I'm talking about procedural law. And then substantive law will be the right itself, or rules or limits. One more example. You may have a right not to take a certain course in your program because you have taken this course with another institution. So this may be your right. How do you have such a course exempted? You need to know what the procedural law is in a way that you properly apply, you properly provide the institution with the documents, and then such a course may be exempted. So one is about the procedure, how to exercise the law. The other is about the right or prohibition itself. Okay. We also categorize law as either public or private law. So public law, briefly speaking, is the law in which the government and people or citizens interact with one another. So the relationship of people and their government. So examples here would be constitutional law, would be tax law, would be criminal law. Why? Because those are all laws that are usually applied, enforced by the government towards their um, people. Whereas private law is usually not related to the government, it's related to only people among themselves. So I have a property, I have a land. No one can enter my land. Yes, because civil law says if someone enters in someone else's land without their authority or authorization, it is trespass. We'll see that in chapter 4. So this is the law, this is property law, which is a type of a private law, which gives me the exclusive right to enjoy my property. No one can enter without my authorization. That's one example of private law. So we have this chart showing some examples, some legal topics or types of law. And with private law, as I just exemplified, I just gave you an example on property law, but there's also tort, we'll see in chapter 4, 4 and 5. Contract law, we'll see in chapters 6 to 9. Property law, we'll see in chapter 13. So they are all examples of private law. And public law They will be constitutional. We'll see in a minute some details. Administrative law. There's a part in chapter 3 about administrative law. Criminal law we don't touch upon in this course, nor do we touch upon tax law. So those are two um, examples of public law that we don't work with in this course. So now we look at legal systems. So in the world, there are mainly two different legal systems. One is the civil law legal system. By the way, the one my background is about, because I'm a Brazilian foreign lawyer. So in Brazil, our system is civil law legal system. But also the civil law legal system is present in Quebec, here in Canada. But in most cases, countries are either civil law or common law. Canada is one exception because Canada there's both civil law and common law within the country. Well, the first thing to know here is that civil law in Canada is, as a legal system, is present only in Quebec. A second important aspect here is that civil law legal system is only important for private law. So we just saw some types of private law. I'll show you again: property, tort, contract law. So in Quebec, it is civil law legal system for property law, tort law, contract law. Okay? But not for public law. Public law in Quebec, as everywhere else in Canada, will be common law. So that's the second important thing. A civil legal system in Quebec is only related to private law. In other words, property law, tort law, contract law. Okay? And what is the main characteristic of a civil law legal system? The main characteristic is that there is a code known as or called civil law code. So in other words, in a civil law system, laws, they will be codified. They will be written down in a code. So whenever anyone needs to know what the private law is, what rights are there, what prohibitions, what limits are there, they will refer to this code. Judges, when they are rendering decisions for specific cases on private law in Quebec, they will also look at the code. So it is in the code where we find substantive and also procedural law, but most of all substantive law. Okay, so that's very important. All laws are in a code. All private law is in a code, and this code is called civil code. And the Quebec Civil Code actually is derived from the French Civil Code. So in my country, for example, in Brazil, our civil code is derived from Germany. So it's different. There were two main civil codes in the world. And those two main ones were one from Germany, the other from France. So in Brazil, we borrowed the German civil code to establish our legal civil law system. But in Quebec, they used the French civil code. Okay? Now the common law legal system. Well, the common law legal system is the most important for us. Why? Well, first of all, because it is applied everywhere in Canada for public law. And it is applied everywhere in Canada as well, but except Quebec, for private law. So that's why this is the most important. Here in BC, there's only common law. Okay? So what is the common law? Well, common law comes from the common law system comes from England, and the most important characteristic in a common law system is that decisions, past decisions, they become law. So the main source of law will be past decisions and not a code. Even though there's a code, there may be a code in common law, such as the criminal code, but in private law, for example, there isn't such a code. So all rights, restrictions in property law or common law, or contract law or tort law, they will come from past decisions. And those past decisions, they may be binding on other judges. So when we are in law school, we would need to look at dozens, eventually hundreds of past case laws, because it is from them that we learn what our rights are, what our limits are. And in common law, this main characteristic of common law is known as stare decisis. So stare decisis is this Latin expression, and it says that some judges are required to follow precedents. And precedent will be a synonym of past case law. So we can use interchangeably precedent or case law or even past case law. So why did I say some judges are required? Well, it is because we'll learn the court system in Canada in Chapter 3, but for now, we should know that judges from lower courts, they are required to follow decisions from higher courts. They are required. Those decisions are binding. So that's the main characteristic of a common law system. So let me give you this example. About 10 years ago, the Supreme Court of Canada, the highest court in the country, and again, I'll detail the court system in Chapter 3, but the highest court in Canada decided about 10 years ago that same-sex marriage is legal in Canada. So regardless if judges like or agree with this decision or not, they are required to apply this precedent because this decision comes from the highest court in Canada. Okay? I will touch upon this stare decisis again when we discuss the court system in Canada because there are some more details when we talk about provincial courts and decisions from the highest court in the country, which is the Supreme Court. But for now, let's just keep in mind that stare decisis, one of the main characteristics of common law system, says that judges in the lower courts are required to follow decisions from higher courts. Okay? And in Canada, as I mentioned before, both systems exist. So they coexist in Canada. Civil law system only for private matters in Quebec, and common law system for public law everywhere in Canada, and for private law everywhere in Canada except Quebec. Okay? In terms of equity, I don't emphasize this much, but you should know that not only were there common law courts back in England, but there were also courts of chancery. They were known as courts of chancery or equity, courts of equity. And those courts, they were created because the common law courts, they had some limitations to render new decisions. Why limitations? Well, The main one is that common law courts had to follow decisions from higher courts. So there was no flexibility there. So those courts of chancery were created, and some new remedies, some new decisions were able. And judges in the courts of chancery, they were able to apply what is known as the law of equity. So the law of equity was applied in case the common law, the precedent from common law, was not the most adequate decision for um, a specific case in question. But actually, this court of chancery merged with the common law courts, and nowadays we only have the common law courts. What is still relevant, though, is that we have some equitable remedies. So remedies that were created in those courts of equity or chancery, they are still available for common law courts. We'll see them in more details in chapter 3, and also moving on some other chapters. But from equity, you should remember that the courts of chancery or courts of equity, they were the ones creating the equitable remedies we'll see in the future. So statutes are enactments or uh, whatever law that is passed by parliament. Could be parliament, could also be the provincial legislature. So statutes or legislation, whenever they conflict with case law or past case law or precedent, they prevail, they overrule. So whenever a judge is enforcing law or whenever someone is dealing with law and a precedent is in conflict with a statute, the statute will prevail. We'll look at more details on how statutes are created, passed, but for now, you should know that they prevail over past case law. And this is because of this concept that is called parliamentary supremacy. So, moving on, uh, we look at the Constitution. And here we learn why Canada is Canada the way it is today. So it is Canada the way it is today because back in 1867, the British passed the British North America Act. And this act, which is nowadays known as the Constitution Act of 1867, created Canada with a federal government taking care of the whole country, but made of provinces. And provinces, they also have their power. So the Constitution Act of 1867 is the one that created Canada as it is. It made Canada not so dependent from the British. Still dependent on some extent, but not so much because the country was created. If you were in Canada 3 years ago, you may remember that the country celebrated its 105th anniversary. And the Constitution of Canada has principles, and the one I want to emphasize here is the rule of law. The rule of law is a very important principle. Again, in law school, we would be studying this for several weeks or months. But for us, it is enough to understand that the rule of law means everyone in the country is protected from arbitrary actions of the government. Or in other words, everyone is subject to the law. Even the prime minister, even the premier, even police officers. So anyone in Canada, they are subject to the same law. So that's the rule of law. It helps uh, to make Canada a democratic society. And then after this Constitution Act, we have the Constitution Act of 1982. This Constitution Act is important mainly for two things. The first thing is that it made Canada fully independent from the British. So from 1982 on, Canadians, if they wanted to change their constitution, if they wanted to change their form of government, they would do this by themselves. They wouldn't need prior approval from the British. And the second important aspect from the Constitution Act of 1982 is that it brought to us the Charter of Rights and Freedoms. We'll see the Charter in more details in a little while. But for now, we should remember that the Charter came into existence, and such an important Charter, back in 1982. So it's been almost 40 years that the Charter exists in Canada. And what is Canadian Constitution made of? So it has basically three elements, which are statutes. So it recognizes statutes, law that is passed by the Parliament or the legislatures, and also case law. That's why Canada is a common law jurisdiction mainly, except for private law in Quebec that we saw is civil law system. And there are also conventions. The Canadian Constitution recognizes conventions, and conventions will be mostly unwritten rules that say how the government has to operate. There's I it's not needed to look at examples, but we need to the main one would be here the rule of law. The rule of law is a convention, is an unwritten rule that is applicable in Canada. So that is very important, and we just discussed the rule of law. And deriving from the Constitution, it is important for us to know that sections 91 and 92, they divide powers between the federal and provincial governments. So you don't need to memorize this in detail, but you need to understand how this functions. So section 91, for example, says that criminal law is the exclusive power of the federal government. So that's why it was the parliament that changed the criminal code for marijuana possession. If the provincial governments decided to change that, it wouldn't work because only the federal government can pass criminal law. This is prescribed by Section 91 of the Canadian Constitution. Whereas property rights, civil rights, healthcare, those are under the exclusive powers of the provinces. So you may know, or if you don't, you may just Google to learn a little more. But here in Vancouver, we have the safe sites, safe sites or safe injection sites. So those are places where people can get drug supplies, not the drug, but the supplies. The federal government was not happy with those and wanted the BC government to shut them down. But the provincial government, the BC government, said, hey, healthcare is under our exclusive power here in Canada, based on Section 92 of the Constitution. So we want to keep them open and we will keep them open. So, and most recently we had the Kinder Morgan pipeline issue. And from one of the decisions I read, the judge said both governments were correct. The federal government was correct in allowing the business to move forward because It is an interprovincial business under the exclusive power of the federal government. However, the judge said that the provincial government was also right based on property rights, saying that if the federal government wanted to proceed, they would need to comply with local requirements, licensing requirements. So those are examples of how sections 91 and 92 work, function. And it's common that federal government and provincial governments have a fight or a dispute based on their exclusive powers. So courts, whenever needed, they will apply interpretations to sections 91 and 92. Again, you don't need to memorize those, they are just examples. You need to understand the rationale of this. Okay? Branches. It is very important to understand branches. So I've been talking about mostly two branches so far. I've been talking about decisions, case law. So all this come from the judicial branch, or in other words, from the courts. So the courts, they are one of the three branches. And I've been talking about statutes, acts. So this is the law that is passed by parliament or legislature. So they are the legislative branch. And we have a third branch, that is the executive branch. Prime Minister and the cabinet, or the premier here in the province. So judicial branch, they are there to adjudicate cases, to render decisions, to solve disputes. The legislative branch is there mainly to make legislation, to make statute law. And the executive branch is the one that runs the country or runs the province. And how do they run? They implement the law. They can only act when the law allows, when the law permits. So they are the executive branch. So it's important to understand those three branches we have in Canada. So this is a summary, very interesting summary. Again, the three branches, legislative, executive, and judicial, and who they are, parliament or legislature in the province, what type of law they make. So legislative branch, statute law or legislation. The executive branch, as I just said, prime minister, cabinet, premier and cabinet. What kind of legislation they make? They do make legislation. They will make regulations or bylaws. Bylaws by municipalities. And regulations, what are regulations? Regulations, they are actually more detailed laws derived from acts, from statute law. So let me give you these two examples. We have the Income Tax Act, that is legislation, that is statute law. And then there are several income tax regulations. So usually the regulations, they are dealing with procedural law or details that were not dealt with in the statute law. We also have Immigration Act, so a statute law, and then we have several immigration regulations, and they are usually numbered. Okay? And the judicial branch, as we know, they are judges or courts. And what kind of law do they make? Case law, past law, precedent. So this is the main characteristic of common law system. So this is a very nice table to go through. Okay. So in terms of system of government, you can just review this. I just want to call your, well, we're going to look at this next chapter. and we'll be focusing on the Supreme Court of Canada, so the court system, and then the provincial courts. We will not look at the federal courts or tax court. We'll only focus here on the provincial courts. Okay? So, in terms of indigenous rights and self-government, it is very important here for us to understand and know that Canada recognizes the indigenous self-determination and self-government right. And they recognize this, they accept this as an inherent right. An inherent right meaning that those were rights that pre-existed before the Europeans settled in Canada. And more, both federal and provincial governments, they are coming into treaties with indigenous peoples to recognize more and more of their rights. So here, this is also important to know and to understand. So moving on, whenever those titles are crossed, you don't need to put attention in there. You can just skip. And now we need to look at the paramountcy concept, which says whenever federal legislation conflict with provincial legislation, the federal legislation will prevail. Okay? So the federal legislation, this is not so common, but whenever it happens, the federal legislation will prevail. Okay? That's the paramountcy principle. Um, skipping this. So how are statutes passed or created? How is legislation made? Well, very briefly speaking, and you don't need to memorize all details, you just need to understand the overall concept. Generally speaking, either the executive branch, prime minister or cabinet, they propose a law, that is, this proposal is called bill, or the politicians themselves will propose this bill. So then the bill will be read, will be debated, there may be modifications or not, and then once approved by majority, then it will gain status of law after the royal assent. So when the royal assent takes place, it becomes law. It becomes valid law in Canada. The act becomes the act will have its full force, its full effect in Canada. Okay, or in the province if we're talking about provincial act. An example of a provincial act will be, for example, the Insurance Act here in BC, the Employment Act. So those are read, debated, and then approved by the provincial legislature, not the federal parliament. Okay, so now the last part of this chapter is related to rights and freedoms. So it is important here to understand and know that there are two streams of legislation with regards to protection of rights and freedoms. One stream will deal with abuses by the government or governmental type institutions. Those would be hospitals, educational institutions, because it is understood that those types of institutions, they provide governmental services. But whenever the government abuses on our rights, we will rely on one of the streams, one of these two streams of legislation. And the other stream is related to discrimination by society at large. So this is when one individual discriminates another. or one private company, one corporation discriminates on someone, then we will rely on this other stream of legislation. And we'll look at both as we finish this chapter. So the first one, the first stream, will be the Charter of Rights and Freedoms, the one that came into existence in Canada with the Constitution Act of 1982. The Charter of Rights and Freedoms will prescribe that our rights, they will be protected by judges. They will be protected by the courts rather than the governments. And why? Well, because the charter is the law that we will rely on if the government abuses on our rights. Then if the government is the one abusing, why would the government protect our rights? No, it is a different branch. So the judicial branch, the courts, they will protect us. So whenever we feel our rights were abused, were infringed by the government, we will go to court. We will sue the government. Okay? And we'll look at some details of the charter. But now, before we look at those details, we need to understand that the charter has some limitations. And the first one is the one I just said. The first one is in section 32.1 that says that the charter will be only applicable to governmental or government-related activities. The other limitation that is important is on section 1. Section 1 says that, yes, sometimes governments can abuse on our rights and freedoms, as long as those abuses, they can be justifiable in a free and democratic society. And I have a very recent example to give you. Very, very recent. Well, have the governments not interfered in our right of way? Have the governments, both the federal and provincial governments, demanded businesses to close, people not to go out? We could not go to parks because of COVID-19. Well, this is an abuse in our rights. We have the right to go. We have the right of way. We have the mobility rights. But then the government, they interfered with this right. Why did they do this? Because of this pandemic. So this is an example in which a government may interfere in our rights as long as such interference can be justifiable in a free and democratic society. So I would say that this is justifiable. This is not an act of a dictatorship. No, it is just because of the pandemic. And now governments are relieving some of those restrictions. So this is just a real example. But in most cases, Section 1 will be brought to the attention of the judge whenever a person or company is suing the government, claiming that their rights were abused. So, first of all, the court will decide if the rights were actually interfered with, and if they understand yes. The second question they will make is, but was this interference justifiable in a free and democratic society? If they say yes, it is justifiable, so they will accept such interference. But if they say no, it is not justifiable, it is too much, then they will strike this law. They will strike that interference, that abuse. Okay? So that's how this limitation on Section 1 functions. The limitation on Section 33 has not been used in Canada a lot, and I have also provided you with a handout on it. So, but you don't need to bother much on this. Okay? So let's look at some of our fundamental freedoms. In Canada, we have the freedom of conscience, religion, freedom of thought, expression. But there's one thing that is important here. Our freedom is not unlimited. There are limits to our freedoms. And the limit is related to I cannot I cannot enjoy my freedom in a way that I cause damages or losses to someone else. So the freedom of expression, for example, I can express anything I want as long as I am not committing defamation, as long as I am not issuing a false statement about someone, for example. So yes, we do have freedoms, but they are not unlimited. There are limits to them. Okay? We have democratic rights. So an example here, election every 5 years, so that government may change. We have mobility rights. As I said, we have the right to go, to stay. But again, on the example I gave you, the restrictions for COVID-19. We also have legal rights, very important. Section 7 says we have a right to life, liberty. Sections 8 and 9, very important because they prohibit activities as unreasonable search and seizure and also arbitrary imprisonment. So it is not always that a police officer may search and seize something that belongs to you. There are restrictions, and we are protected from those unreasonable search. For example, if a police officer comes to search my house, the police officer needs a warrant. The exception is that when a crime is happening at that moment, then a warrant is not needed. But if there isn't a crime happening, I am protected from an unreasonable search, for example. Equality rights, so everyone is equal to the law and there can't be discrimination. Language rights, French and English, they have equal status in Canada. So if you are a foreigner when you arrived in Canada, you saw signs at the airport, both in English and in French, because federal government services, they have to be delivered in both languages. Not delivered, but they have to be available in both languages. Okay? So those are some of our freedoms and rights from the Charter. Again, remember, the Charter will be only applicable if it was the government that abused or interfered with our rights. And if this was the case, we need to sue the government because the Charter says the judges, the courts, are the ones protecting us from such abuse or interference. Okay? The second stream of legislation will be the human rights legislation. And we have both federal and provincial legislation that protects us from human rights violations. So if your friend, your neighbor, your boss, a supervisor discriminated on you based on, let's say, so the human rights legislation will be the one protecting us when we are discriminated on gender, religion, race, age. We will not rely on the Charter, but on the human rights legislation. For us here in BC, we have the Human Rights Code. Very good human rights code. So if you believe you were a victim of discrimination by a private company, by an individual, you will rely on the code. And by relying on the code, we actually do not sue the wrongdoer. The person or the company who allegedly discriminated us will not be sued. What we will do here, we will file a complaint with the Human Rights Tribunal. So that's a very important distinction from the Charter. The Charter, I told you, they are only applicable for governmental abuses, and the victim will sue the government in the courts. Whereas the human rights legislation, they will be applicable to people among themselves or corporations, not the government. And yet, the victim will not sue, but the victim will file a complaint at the Human Rights Tribunal. And I will detail more the role of tribunals in our system in chapter 3. Okay? But for now we should know that we file complaints. And companies, they have a duty to accommodate issues related to the protected grounds. So let's say my religion says that I cannot work on a specific day of the week. So the company has to accommodate my need. But such accommodation is limited to the extent that it does not cause an undue hardship. If I'm talking about a small company where there's the owner and myself as an employee only, and if I don't show up to work at that day that I can't because of my religion, then it means it would cause an undue hardship for my employer. So in this example, the employer would not need to accommodate. But if I'm talking about a bigger company, and the fact that I am not coming on a certain day because of my religion, and the business operations are still okay, then yes, I do have the right to be accommodated. Okay. So that's what I wanted to share with you about human rights legislation. Remember, protections are mostly related to gender, religion, ethnic origin, race, age, and disabilities. Okay? So that's what I wanted to share with you on chapter 2. We discussed how law is defined, types of law we have in Canada, and sources, who create them, where they come from. We also looked at the distinction of civil law and common law systems. We touched upon the Canadian Constitution, mainly the Constitution Act of 1867 and the Constitution Act of 1982. And we ended by looking at protection of rights and freedoms, by the Charter of Rights and Freedoms, and also by the human rights legislation. Thank you and bye for now.